welcome to our viewers in Nigeria and across the world. Lunchtime Politics begins right now. Supreme Court declines application to release leader of proscribed indigenous people of Biafra, IPOB Nnamdi Kanu, from DSS detention, insists he must face trial at the Federal High Court. The Rivers political drama continues as more resignations hit the Rivers state government as 3 more commissioners bow out of the cabinet, swelling the list of resigned cabinet members to 7. An office of the Senate President refutes claims that he collapsed after the colloquium in celebration of his 61st birthday and was rushed to the hospital. Well, we'll begin with breaking news at this hour. The Supreme Court has upheld the federal government's appeal challenging the verdict of the appellate court that dismissed the remaining charges on the leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu. The court insists that he must face trial at the Federal High Court. But Justice Emmanuel Agim, who delivered the judgment prepared by Justice Garba Lawal, held that the Court of Appeal was wrong to hold that Mr. Kanu could not be tried again based on the illegality perpetrated against him by the federal government following the invasion of his home. Although the court held that the Nigerian government was reckless and unlawfully rendered Mr. Kanu from Kenya, it however said that such unlawful act has not divested any court from proceeding with trial. Justice Lawal said that no Nigerian law was cited in the suit seeking Mr. Kanu's release on mere unlawful abduction from Kenya, adding that at the moment, the remedy for such action is for Mr. Kanu to file a civil matter against such act instead of removing the powers of courts to continue with his trial for alleged criminal charges. The Apex Court subsequently allowed the appeal of the federal government and dismissed a cross-appeal filed by Mr. Kanu. Well, let's now bring you more on this. We're joined by our legal correspondent, Emanuela Ekele, who is live at the Supreme Court venue of that judgment. She's been following this case from its entirety. Well, Emanuela, yet another twist, it would seem, to this case. But what more can you tell us about this judgment?
The line is breaking. I can't hear.
Well, Emanuela, if you can hear me, I'm just asking, what more can you tell us about the judgment from the Supreme Court today? I understand there's a lag, so we'll just accommodate that lag.
Hello, Kayode. I can tell you that these are not the best of times, apparently, for the leader of the indigenous people of Biafra, that's Mr. Nnamdi Kanu, and his supporters, as they were expecting that he will be let off the hook today by the Supreme Court, just as the court dismissed the appeal that they brought challenging, the cross-appeal initially challenging the decision of the Court of Appeal for stay of execution, and the court upheld the decision of the Federal High Court, of the federal government, I beg your pardon, which had said that Mr. Nnamdi Kanu had a case to answer, and they had charges that they were going to bring to ensure that he committed acts of alleged treason, felony. So now I can also tell you that the reasons why the Supreme Court justices held on to their decision was based on the fact that, despite the fact that they slammed the federal government, that the way he was brought back to the country to face the charges was illegal. Jurisdiction of any federal high court that cannot try Mr. Kanu, and that he should go back to answer the charges that was before him. I can also tell you that the justices also slammed the federal government for what they call the image of the country, that they should also look at how they hold in the image of the country locally and internationally before other countries around the world. And I can tell you that it's not a good time for Nnamdi Kanu. Now, we also spoke to the lawyer for Nnamdi Kanu, and they said they still believe that there's light at the end of the tunnel as they're ready to go back to the Federal High Court to face the remaining set that is before Justice Binta Nyako. I can also tell you that the case, 8-count charges were initially removed by Justice Binta Nyako and was left with 7-count charge. So that is the remaining 7-count charge that he's going back to the Federal High Court in due course to face. Kayode.
Well, so it's back to the Federal High Court then, Emanuela. Thank you for your coverage on this. And of course, we'll be following this matter as it unfolds. Thank you, Emanuela. Well, we know that this is a case that began with the previous government, the Muhammad Buhari administration. But let's give you even more insights, this time from a legal perspective, a legal practitioner who was live in the Supreme Court when the judgment was being handed down. We're joined now by Dr. Monday Ubani, former chairman, Section of Public Interest and Development Law, Speedo of the NBA, joins us from our Abuja studio. Oh, Dr. Ubani, it's good to have you on the program. You were there when that judgment was being read by Justice Lawal, and you have followed this case all through. Well, seeing how this has ended, at least at the Supreme Court, what are your thoughts to begin with?
Yeah, thank you. It was sheer coincidence that I have a matter that also judgment was delivered today. So I was happy that Nnamdi Kanu's matter was also coming up today for judgment. So it was more than hopeful. But unfortunately, the Supreme Court agreed with the state that the court cannot be divested of jurisdiction, despite the fact that the court acknowledged the fact that a lot of irregularities and illegalities were committed by the security agencies. One, in invading his home in Umuahia, trying to get him arrested when there was no order of the court revoking his bail, because he was under bail. And so there was no reason for that invasion when there was no revocation order by the court. So the Supreme Court adequately condemned that particular act of invasion without any order of court. The Supreme Court also condemned the security agencies, for going to Kenya, trying to get Kanu arrested. And in fact, the court used the word kidnapped, that he was kidnapped and brought back to Nigeria. Now, that particular act, contradicted and contravened all known international laws, including the law of Kenya and then the law of Nigeria. That is what the Supreme Court said. So the Supreme Court took time to educate security agencies that carrying out enforcement of the law does not in any way encourage illegality by these agencies, that they must enforce the law in accordance with laid down rules, and that is rule of law. After saying all these nice things, and we were hopeful that the next pronouncement will be that Nnamdi Kanu's matter will be settled finally today. But unfortunately, what the court said, there is no legal framework, there is no law presently in Nigeria that outlaws issue of illegally obtained evidence or whatever way with which you bring an accused person to court. That even if you bring the accused person into court in an illegal manner, that there is no law today that says that that particular act will not divest the court of jurisdiction. It's a different matter whether whether the prosecution will succeed in proving the issue of charges you have leveled against that individual. It's a different ballgame entirely. But the point is that can the court, based upon our legal framework, our legal existing law, be divested of jurisdiction because the person was brought to court illegally? The Supreme Court now says, there is no such law, and until such law is enacted, they are not ready to enact any law giving such act of illegality as a way of saying you cannot have jurisdiction before the court because of that illegal act of the security agency. That is what the court simply said today and all that, So I was there live.
But we also know that, it's always said in law that the process is equally as important in the build-up to reaching the eventual decision. And there's the Evidence Act, as far as we're aware of. Now, I think the question is whether the Evidence Act appropriately covers this particular scenario. But you've said that the court condemned the process of bringing him to court, the way the federal government acted through its actors and the rest. So is this yet another judgment that has been, well, tainted by that technicality issue, which we have seen come up time and again. Your thoughts?
Well, my sincere opinion, if you ask me as an individual, I may be wrong, is that I am at home with the Court of Appeal decision, saying that, look, if the process through which you have initiated somebody's prosecution is clearly illegal, then I think that this is what should happen. You shouldn't try that person for that offense because the process was absolutely wrong. I am totally. But the Supreme Court today said no, that was clearly application of sentiment by the Court of Appeal because there is no law today in Nigeria, in our legal books, that says that process divests the court of jurisdiction. So, honestly, if you are as an individual, I may be wrong, as I said earlier, I am at home with the Court of Appeal decision. The Supreme Court has the final say, and that is it. And if the Supreme Court said this is what the law is, there is nothing anyone can do about it. But they made it clear that all the actions of the security agencies with regards to Nnamdi's matter was clearly a transgression, a very gross transgression of the law, a great violation of his right. And that again gives some level of comfort, that everything they did, especially when somebody is being tried for an offense and he has been granted bail, and there is no court order revoking that bail. Why do you have to do what you did? And then why do you have to now say he has committed an offense when he now took a flight, because he had to save his life? So why do you now want anything to happen to you? But let me also say what the court said. In everything that the security agencies did against Nnamdi Kanu, that was a clear violation of his right. Where his remedy lies is in the civil action. He can bring an action against them and claim all manner of damages, amount of money in billions or whatever they want. That is where they now have a right to go in terms of civil action. But in criminal, that act of illegality does not divest the court of jurisdiction. That was expressly made clear. And to me, that probably is a law today, based by the Supreme Court, because they are the court of final decision, and they have made that decision, overruling what the Court of Appeal said. But if you ask me as an individual, I am more at home with the Court of Appeal decision that if you bring somebody in an illegal manner to a court that does not in any way conform with all known laws and procedure, then it means that you cannot in any way, have jurisdiction to try that particular person of that offense. That I am as a human being. But the Supreme Court has the final say, and they have spoken, and there is nothing anyone can do about it. But the point is this. Mr. Chief Agabi was there, who happens to be the lead counsel, also took the hint and said maybe we have to go back to the legislature, in order to enact a law that if you do something that is clearly illegal, in order to try a criminal offense, and you commit crime yourself in trying to now prosecute a criminal, then a suspect, then everything that you are doing is clearly a nullity. Maybe we have to go back to the legislature and ask them to now look at it and probably take a decision. For now, the Supreme Court said there is no legal fraud, there is no law that backs it up, and we cannot in any way now say anything otherwise. Whatever I say is my own opinion, and it does not in any way divest the fact that the Supreme Court has the final say on this issue.
And we see that the Supreme Court, in its wisdom, perhaps is trying to separate the issues, the charges brought against him by the federal government, and then the grounds he has against the process with which he was brought in, which, as you said, the Supreme Court had condemned and eventually said that he should file a civil suit against that. Is that something you'll expect his legal team to pursue in this case now? And will that have an effect on the charges which he's answering to, charges brought against him by the federal government, if he were to file a civil lawsuit?
Now, what the Supreme Court also said, look, the chances of success of the criminal prosecution is not what they want to delve into at this point, because there may not be a substance even in the charges. It may turn out to be there is no substance in the charges, and of course they have very brilliant lawyers, to handle the defense. So they want to make that distinction. But the fact that we're asking this matter to be tried at the Federal High Court does not mean there is any substance. We're not approving of the allegation of crime against him. No, we're not saying so. That is what that judgment says. But that he should not be tried at all is what the court now says no. There is no law that says if you bring somebody in an illegal manner, he is not supposed to be tried by any court. That's what the court said. But the court also gives some level of comfort and say, look, I condemn this. So in fact, the court has given judgment even in the civil matter by the pronouncement of the Supreme Court today. They say it's clear violation of his right. It's a clear transgression of all known laws, both treaty, local, and international. They said that. And that the only remedy for him now is to seek remedy in the civil action. So they said that for me, judgment has already been given in the civil matter. If the Supreme Court could, do what they did, with that condemnation. So the legal, team of Nnamdi Kanu, clearly got the hint. And so I know that they will do the needful. But the most important thing is that there should be a expeditious trial of Nnamdi matter. If I may suggest. If anyone says now he has a charge against Nnamdi Kanu, can we commence the process, very quickly, and let us get over this matter? It's lingered for a long time and has created some level of, really, crisis and incohesion in the southeastern region. And everyone who is from that region is expecting absolute peace in the region. And we felt that this would have been a very golden opportunity for us to put to rest this matter and begin to have peace, and all that. But unfortunately, what the Supreme Court said today, let him go and face this trial and all that. We don't know how long that will last again, from the lower court to the Court of Appeal and Supreme Court. To me, I don't know as a nation. I don't know what we need to do at this point in time, because I thought that this matter, should have been sorted out, probably outside the jurisdiction of the court, maybe politically. That's right. And we have called on the president of the country to see what he can do to intervene in this matter. And let's have peace in the south and east, so that those who are really criminals can be identified, because they are using this issue of Nnamdi Kanu detention to cause a lot of havoc in the south and east region, and everyone knows it. And
well,
so
Dr. Bani,
I would want the Supreme Court. I would want yes.
You were talking about political solution.
What I was saying, yes, what I'm saying that the president of the country, everyone has been saying, including the Ohanezes, all the stakeholders in the southeastern region, including governors, have actually stepped up and said, look, is there anything we can do, sir, in order to have this matter resolved? Because it's for the sake of the peace of the nation, sake of having absolute peace in that region. And every region must bear some level of sanity for good governance at the federal level. So I think that the president at this juncture, once again, we are using this opportunity to really appeal that we should have political solution to Nnamdi matters. Is very important. Very important.
As we wind down on this conversation, clearly this is not the end, because there's still more to come at the Federal High Court, and of course, perhaps escalate even further. But as you said, this is not in isolation. This is happening within a broader, political context, regional issues, agitations are there. With this latest judgment, how would you advise that it be taken by the parties? There were a lot of people looking forward to this, the Southeast, there's still been the challenges of, sit at home, the security unrest and economic damage which this is causing to the Southeast. So what would be your advice in terms of taking this on board for the major stakeholders, the leaders, and the people particularly?
Thank you, Kayode. All hope is not lost. And I'm not ignorant of the fact that the federal government may not be unmindful of having this matter resolved. So I believe that there are still ways out of this quagmire. Now, as the Supreme Court has finally led to raise the issue of whether the court should be divested of jurisdiction, now we are going back to the Federal High Court. There is nothing stopping the federal government now, through the Attorney General of the Federation, to enter a nulli, concerning this issue of going back to trial. That would be a way, maybe that process now has been created, opportunity now has been created. Or go back to the Federal High Court. Now the federal government comes out of the way and say, look, gentlemen, we don't want to proceed in criminal trial of this young man. Let's have absolute peace in the region. And then enters nulli. And that is it. That brings to end the matter. So that opportunity is there. So anyone in the southern east at this juncture should maintain peace, because peace is key for development. We cannot in any way develop as a nation, including the eastern region, if we will begin to create unnecessary crisis. This sit at home every Monday is causing what we call economic havoc to the southern eastern region economy. And it's not something anyone that loves the southern eastern region should do, even as a citizen of that particular region. So we want absolute peace. All hope is not lost. All hope is not lost. And I think that the president have his mind towards this, that something will be done practically very soon concerning this issue of going back to trial. Right. A nulli can be entered, and then that will be the end of the matter. So please, nobody should create any crisis or cause any havoc. or insist on sit at home when it becomes very unnecessary and is hurting the economy of the southern eastern region. It's hurting our economy. Everyone knows it. Every governor knows it. Every citizen knows it. And the fact is that it is about us. It's not about those who are in government. We are the one hurting ourselves by doing that. So I think we should maintain peace in this jungle because all hope is not lost. And I think that the president of the country has his mind towards having this matter resolved. He has said it several times, and I think he will, at this point in time, do something that will really make everyone to be happy. It can be a Christmas gift for all of us. This can be a Christmas. Somebody can come up tomorrow and say, we're no longer interested in prosecuting. Enter a nolly, and that's the end of it, and there will be joy in the land. And there will be joy. I was hoping for that joy today, but all hope is not lost. But it will happen very soon. I'm very optimistic about that.
Dr. Nnamdi Ubani, former chair, Section of Public Interest and Development Law, SPIDL, at the Nigerian Bar Association, thank you so much for your time on Lunchtime Politics.
Thank you for the opportunity, Kayode. Thank you very much.
Well, away from the courts now, it looks like it's clearly a resignation season, you can call it that, in Rivers State Executive Council, where commissioners there have been quitting their jobs. So it started with the Commissioner for Justice and the Attorney General of the state tendering his resignation yesterday. And ever since then, 6 more commissioners have handed theirs in. 4 of them resigned yesterday, while 3 more have so far resigned. Now, those who have resigned so far are the Commissioner for Justice, of course, and the Attorney General, Professor Zacchaeus Adango, and the Commissioner for Works, Mr. George Kelly-Alabo, the Commissioner for Social Welfare and Rehabilitation, Mrs. Inime Aguma, and the Commissioner for Education, Chinedu Mom. Well, others are the Commissioner for Housing, Gift Warlu, the Commissioner for Transport, Jacobson Bina, and the Commissioner for Finance, Isaac Kamalu. So far, 7 out of 18 Executive Council members have thrown in the towel, leaving the Council with 11 EXCO members. Now, most of the commissioners cite personal reasons for their decisions, but many believe that it may not be unconnected with the Cold War between the state governor, Mr. Siminalayi Fubara, and his predecessor in office, current FCT Minister, Mr. Nyesom Wike. Well, let's get more insight into this. We're joined by the Commissioner for Information in Rivers State, Mr. Joe Johnson. He's been speaking a lot about the recent issues, so let's get his thoughts on the recent gale of resignations. It's good to have you on the program, Mr. Johnson. Well, if you can hear me, Mr. Johnson, if you can hear me, I think the obvious question to begin with naturally is, are you resigning also? Okay, looks like we're trying to fix the audio connection with Mr. Joe Johnson, the Commissioner for Information in Rivers State. We've since seen 7 of his colleagues resigning. Okay, there you go. Mr. Johnson, if you can hear me, I was asking, to just clear the air, are you also planning to resign? Have you resigned, or you're staying back in the EXCO? Please unmute your microphone so we can hear you, Mr. Johnson. All right, we'll get Mr. Johnson definitely during the course of the program, just to get us a view of what exactly is playing out in Rivers State, where in fact some political leaders from 17 wards of Obiakpo local government area have thrown their weight behind Governor Siminalayi Fubara and Edison Ehie, urging them not to be distracted by the political happenings in the state. Well, the group is also calling on the FCT Minister, Mr. Nyesom Wike, and state lawmakers who are under the Martins Amewole group to sheath their swords and embrace peace. They also resolved to begin grassroots sensitization for a fresh election into 2 state assembly seats in the area, including that of Martins Amewole, on the claim that a defection from the PDP to the APC has nullified their election.
The Rivers State governor has not failed the people of Rivers State, in particular Obiakpo local government, since after he has been elected as the governor of our state. Obiakpo local government has ruled for 8 years, and we are here to support the other tribe, the Riverine, to do the tenure of 8 years.
We are law-abiding people, and we resolved over time, even before now, followed in the campaigns to elect Sasimilaye Fubara. And he is going to rule completely. Nobody will stop him. Former House of Assembly members, the ones of Obiakpo, are now former. And the party at the national level have directed that the needful should be done, that they should conduct another election so that we will fill in new persons that will take over their position. That is our resolve, and we are going to follow it to the latter. After this communique, now the next action will be sensitizing our people in all the communities to ensure that, following the law, that we have representatives in the assembly, in the state assembly. That is our resolve.
On the flip side, the All Progressives Congress in Rivers State has vowed to defend the mandate of the lawmakers who defected from the People's Democratic Party, PDP, in the state. While addressing a news conference in the nation's capital, Abuja, the chairman of the caretaker committee of the party, Mr. Tony Okocha, says the party will not allow anarchy and chaos, as it will clearly have the majority of lawmakers on their side. The chairman explains that it is an aberration for the state governor, Mr. Siminalayi Fubara, to present a budget proposal to only 4 members of the State House of Assembly.
Assuming we are not considering that the other 27 members were dead, 4-member assembly in a 31-member house does not qualify as 1/3 and lacks the authority to sit. I don't know if I'm right. I mean, we're all students of history and politics. 1/3 of 31. Okay, let's be liberal, 10. Otherwise, I would have said 11. But 4 persons, 4 members, and they are not opposed. They are not saying they are more than 4. That's my happiness, because of course pictures will speak. You know, they say words speak millions. The pictures speak 10 millions. That's a Chinese adage. Okay, so the 4 persons who sat and claim to have declared the seat of the 7 persons are even in error. It's illegality. They don't qualify. That house ought not to be at all. Even the governor, as I would say, that the governor must not try with illegality, because we as a political party, we are the watchdog. We will fight within all legal means, within all legitimate means, to ensure that the right things are done.
Now, following claims making the rounds about the Senate President, Godswill Akpabio's state of health, a special advisor on media and publicity has debunked rumors that he collapsed in the course of a colloquium that complemented activities marking his 61st birthday. Mr. Semeibo instead said that the rumors were fictionalized extensions of the Senate President's assertion of being tired at the end of the program. Now, part of his statement reads that Senator Akpabio spoke on his feet for more than 30 minutes as he gave the expose of his trajectory in a way as never before. And as the program ended, the president, that's President Bola Tinubu, left the Transco Hotel venue, and Senator Akpabio's expression to those around him that he was tired was escalated to a fainting spell or collapse. He says that this is untrue, and says that aside the fact that the Senate President was exhausted in the hearing of those around him, that he was not rushed in a stretcher to the National Hospital, neither is he indisposed. Well, there you have it, the program for this afternoon. Thank you for joining us. I'm Kayode Okikulu. Goodbye.